think you have apparently filed into Mr. Eppinger's case, or Rule 22. His number gone to our public information office, and if you look on our website, there are very clear instructions about how you're supposed to handle Rule 22. And you're not supposed to file it in the case, and you're not supposed to send it to Chambers. You're supposed to send it to our public information office, and then they take it from there. But I mean, I am aware of it, so just in the future, if you can try to do it the correct way.
Of course, I think my colleague filed that one, but
okay, well, yeah, you can blame it on your colleague. That's fine. But anyway, in terms of, I do not mind if you have and I don't even know if notice went to anybody or if anybody is going to have any objection. That's one of the reasons why it needs to be done a particular way. So I would have to find out when we have everybody here, but assuming no objection, you certainly may use your laptop. And if y'all have a still photographer ever, that's welcome. Any other kind of like feed can just go through the pooled camera. All right. So we'll just wait till we get everybody before we get started. Other than that, I'm going to rearrange my
Position number 6. Indictment 24 SC 001711 Beverly Range. Ms. Rondon. Okay. Let's try position number 3, indictment 22 SC 185439, Aquila Carter.
Judge, I'm going to try to get in touch with him. I expect him today.
All right, position number 4, indictment 24 SC 001756,
Custody.
Tashawn Hodge. All right. Mr. Marquez, are you representing the state?
I am, Your Honor.
Okay. Good morning, Mr. Hodge. This is indictment 24 SC 001756. Ms. Jones is present representing Mr. Hodge. Mr. Marquez is representing the state. The calendar reflects we're here for a final plea. What are we doing, Ms. Jones?
Mr. Hodge is going to maintain his not guilty plea, Judge.
All right. Any outstanding issues, Ms. Jones?
Not that I can think of right now, Your Honor.
All right. With that being said, you will be put on a trial calendar and be notified accordingly. If there's nothing further, all parties are excused. Okay. All right, let me go back to that.
Judge, can I have 2 minutes to?
Sure.
If I can. Thank you, Judge.
Is Attorney Lewis present in the courtroom?
I'm sorry, Your
Lewis?
Yes.
Okay, before you arrived, the state announced that on indictment 22 SC 182298, Denise Dillard, that they are going to know and process that case.
Judge, of course you know I have no objection. And it is good to see you. I saw the meeting here and I said, oh, they do you on the bench too. And you told me it was for something else, so.
Of course.
Judge, is it possible to have this matter sealed without a formal motion, or do I need to send that? I can do that.
As long as the state isn't objecting, so you can get with the state.
Okay, I'll do that.
Mr. Marquez just stepped out, but you can send him an email or follow up.
Yes, ma'am.
I don't think it'll be a problem since they're not proceeding.
Yes, ma'am. Sounds good. Thank you, Judge.
All right, if there's
My
nothing.
business being concluded, my client and I be excused.
I was just about to say, unless there's something further, all parties are excused.
Thank you, ma'am.
All right,
Have a great day.
you too.
Cheers.
Deputy Hudson, let me know when something's ready.
I will, Your Honor.
Mr. McMullen, but we have the counsel for everybody else, so we'll just go ahead and get started with the final pleas for those people. Are there any guilty pleas that are going to be tendered today by any of the attorney, any of the defendants?
Yes, Your Honor, Anastasius Nettis on behalf of Mr. Miles Farley, we have a
All right, why don't y'all come on up to the podium, please? All right, Mr. Body, whenever you're ready.
For the record, this is
And everybody, I'm just gonna give a reminder to just use the mics that are in front of you, and they're mobile, so you can move them up close so that everybody can hear.
This is indictment number 22 SC 183-572, State of Georgia versus Mr. Miles Farley. Farley, if you'll please raise your right hand. You solemnly swear and affirm that testimony about to give the matters pending before this court will be the truth, the whole truth, and nothing but the truth, sir? Yes, sir. Hey, put your hand up. Could you please state your true, correct, and legal name for the record? I'll let you sign before I ask you more questions. So, two things at once.
And Mr. Body, maybe reposition the mic while he's doing that.
Yes, Judge. Mr. Farley, could you state your true, correct, and legal name for the record? Farley. And Mr. Farley, are you at this time taking under the influence of any alcohol, drugs, or medicine? No. Is there any medication that you take daily or regularly that you have not taken today that would affect your ability to understand why you're here? No. And how old are you, sir? And how far have you gone in school? I got a bachelor's degree. And are you able to?
Can you also speak into the mic, please?
26 and got a bachelor's degree.
And so are you able to read, write, understand the English language? Yes. And do you understand you are charged in indictment number 22 SC 183-572 with count 1, conspiracy to violate RICO, count 49, which is related to the homicide of Mr. Drinks, counts 50 and 51, which are both participation in criminal street gang activity, and then count 54, which is a possession of a firearm and the commission of felony. You understand you're currently charged or indicted with those counts? Yes. And do you understand that you have the right to plead either guilty or not guilty to these charges? And if you pled not guilty or remain silent, you may receive a jury trial. Yes. And has your attorney, Mr. Menendez, gone over the rights that you're waiving by taking a guilty plea here today, sir? Yes. And are you satisfied with the services that your attorney has provided? Yes. And do you need any additional time to talk to your counsel about any of the facts and circumstances regarding the charges and the circumstances of this case? No. And Mr. Menendez, do you waive formal reading of the indictment?
So waived.
Do you waive any and all defects in the indictment, including any with respect to your client's name for the purposes of this hearing or plea?
Yes, so waived.
And Mr. Farley, has your attorney spoken to you about the minimum and maximum penalty for the counts that you're pleading guilty to? Yes. And he advised that for count 1, RICO, the minimum is 5 years, the maximum is 20 years? Yes. And do you have any questions as it relates to that count, the single count that you'll be pleading guilty to? No. And sir, do you understand that this is a negotiated plea of guilty, which means the state and your counsel will offer a joint recommendation to the court as to the sentencing recommended for the count that you're pleading guilty to, so the court does not have to follow that recommendation, and she can sentence you as she sees fit up to the maximum for the charge. Yes. Do you have any questions about that? No.
Is he just pleading to count 1 and y'all are null processing the rest as a part of the agreement?
That's correct, Your Honor.
Okay.
Now, do you understand Mr. Farley, do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including the federal courts?
Yes.
And do you also understand that if you are not a United States citizen, a guilty plea will affect your immigration status and will result in deportation, regardless of any advice given to you by your attorney or anyone else?
Yes.
Do you understand that you waive any and all defenses by entering a plea of guilty here today, sir?
Yes.
Do you also understand that by pleading guilty, you're giving up or waiving the following rights: the right to a trial by jury, the right to remain silent and to not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or court appointed if you are unable to afford an attorney for the trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and to compel the production of evidence, the right to have the charges proved against you beyond a reasonable doubt by the state of Georgia, and the right to appeal if convicted of these charges after trial. You understand by taking a guilty plea here today that you're waiving or giving up all of those rights?
Yes.
And Mr. Farley, has anyone forced, threatened, or promised you anything to get you to enter a guilty plea here today?
No.
And are you pleading guilty, sir, because you have decided in speaking with your counsel, Mr. Menendez, that you believe that it is in your best interest to do so?
Yes.
And are you aware that even if you're not admitting guilt, as you're pleading under North Carolina versus Alford, if the court accepts that this plea of guilty places you in the same position as if you were convicted after a jury trial?
Yes.
Okay. And how do you plead to count one, conspiracy to violate the Racketeer, Influence, and Corrupt Organizations Act in indictment number 22 SC 183572?
Guilty on the Alfred.
And Mr. Farley, is this Alford guilty plea freely and voluntarily given with full knowledge of the charge that you're pleading guilty to?
Yes.
And do you understand that you may have a limited right to appeal this guilty plea conviction?
Yes.
Do you also understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Challenging anything about the constitutionality of the guilty plea, understand?
Yes, Your Honor.
Well, I want to make sure he.
Yes, ma'am.
All right.
Do you also understand, sir, that you have 30 days from today to file a direct appeal from this guilty plea, and until the end of this term of court to file a motion seeking to withdraw this guilty plea, which doesn't mean that the court necessarily would grant it or not. It's just that's the time constraints that you have to file under those areas of the law.
Yes.
Okay. Do you have any questions about that?
No.
Okay.
All right, and your attorney, Mr. Menadas, will represent you until 30 days from now or the last day of this term of court, whichever is later. And he would be the one to file any of those things on your behalf unless he is allowed to withdraw before that time. Understand?
Yes, ma'am.
And just so the record's clear, I just provided to Ms. Percival the indictment, which was signed by all parties as it relates to
All right.
the defendant's guilty plea to count
Thank
one, conspiracy to commit RICO. Your Honor, had this case proceeded to trial, the state would have shown beyond a reasonable doubt that between January 24th of 2013 and May 8th of 2022, this defendant, Mr. Farley, in conjunction with his fellow co-defendants, co-conspirators, known YSL associates, did unlawfully conspire to conduct and participate directly and indirectly in the enterprise YSL. In doing so, they did it through a pattern of racketeering activity, conducting and participating in YSL with the same common objectives, which were to preserve, protect, and enhance the reputation of the enterprise, that being YSL, doing so by protecting the power and territory of known YSL strongholder areas through acts of violence, also through other means such as social media, posting messages, images, and things of that nature. That's what the state would have shown as it relates to Mr. Farley and his involvement as it relates to the enterprise YSL and his association, Your Honor.
All right, I assume at least some of the evidence would have been the same as or similar to what was presented at the trial of some of the co-defendants that just was completed a couple of weeks ago.
Yes, Your Honor, very much.
All right, so I'll take that into consideration with regard to the factual basis as well. All right, anything else from the state?
Nothing further. The recommendation as it relates to, or the joint recommendation that the parties would make to the court, it's my understanding that the defendant obviously would like to tender his plea under North Carolina versus Alford. And I neglected to ask Mr. Farley, but it's also my understanding he qualifies for the first offender or treatment, and he is asking that the court treat him as a first offender, which the state has no objection to either. And the recommendation will be 5 years to be served on probation.
All right, Mr. Farley, has your attorney discussed with you the First Offender Act and what all that means?
Yes, ma'am.
All right, and have you all discussed the potential upsides and downsides of that?
Yes, ma'am.
You understand that if you successfully complete, if I sentence you in accord with what has been negotiated, if you successfully complete the probationary time without having any violations of your probation, that at the end of that, you would not be a convicted felon, understand?
Yes, ma'am.
All right, you understand as well that if you do not successfully complete that probationary period and your probation is revoked, that not only could you be revoked for that 5 years, but the court could actually adjudicate you guilty, find you guilty, not under first offender, but just straight guilty, and impose up to 20 years imprisonment for the count to which you are pleading guilty under Alford. Do you understand that?
Yes, ma'am.
All right. Mr. Menendez, is there anything else that the defense would like to place on the record?
Yes, Judge, I just want to add a little bit of nuance to the plea in case the court's not as familiar, because a lot of it was on the front end. Mr. Farley is an HBCU graduate with no criminal record, and it's actually his marketing and his genius work as a businessman that even brought him into all of this, which is why we're asking the court to sentence us under Alford. In 2019, him and a friend created a clothing item, a hat that was like a satirical play on the Trump hat where it said "Make America Slime Again" instead of "Make America Great Again." And Your Honor, the clothing brand never said anything about YSL. It was just using this youth term slime, which I'm sure by now the court knows can have many different meanings in many different contexts. Mr. Farley is born and raised in the Cleveland Avenue area, and he does exemplify a lot of the great qualities of the people of that area: his creativity, intelligence, tenacity, his bravery in taking things this far, Your Honor, putting his foot down when he was faced with this, government abuse. But what he did next, Your Honor, is he went to Miles College, and then despite having a vast network of opportunity from his bachelor's degree in business, he returned home because he is a family person. His dad is here in the yellow hoodie in the back. He's also an entrepreneur. That's where Miles gets a lot of that from. And so, Your Honor, when Mr. Farley made this clothing brand, he built off of the hat. In 2020, he made an LLC for Make America Slime Again, and he's actually employed by a record label to be a handler for a musical artist. And then he used those associations and that presence to promote his brand and to have his clothing be as visible as possible. He started making custom pieces for different artists and different people. And Your Honor, if you remember from the evidence that was presented, Mr. Farley's always wearing his own clothing, and he's only ever promoted his clothing for the purpose of himself and his business and his family. And so that's why, Your Honor, I think the most sincere and appropriate way to resolve this case is under Alford. The state, in that respect, did the right thing with its discretion, dropping the murder case. Mr. Farley had nothing to do with the death of Mr. Drinks. And so, Judge, he's been on house arrest. He's been totally compliant. He's not a gang member. He's never committed a crime in his entire life. But he is wearing an ankle monitor. He is confined to his home. It's better than jail, but I think we all know after COVID that that's not necessarily ideal. And he just doesn't want to go to trial. And that's why I think Alford is a textbook case for this type of situation. And so if the court has any questions, we just ask this honorable court to accept the plea as negotiated.
Okay, well, I mean, you know, it would be determined by a jury at trial whether his involvement in the case is only because of his marketing and business acumen or something further than that, something criminal. But in tendering a guilty plea under Alford, Mr. Farley, you are admitting that while you do not believe you have committed the crime of conspiracy to violate the RICO Act, you are acknowledging that there is sufficient evidence that the state could present to a jury from which a jury could conclude that you are guilty of that crime. You understand that, right?
Yes.
All right. All right, I find there to be a factual basis for this plea. I will accept it under Alford and I'll permit it under the First Offender Act. And I find the plea to be freely, knowingly, voluntarily, intelligently entered with an understanding of the consequences. And in accord with the negotiated recommendation, I am going to sentence you to 5 years probation. And as we discussed before, how you perform during the next 5 years of this probation is going to determine whether you finish that. A person who can say that they do not have any felony conviction, or whether you might be spending some time potentially incarcerated. So it's entirely up to you how you comport yourself and how you choose to behave going forward. What ultimately will happen at or before the end of that 5 years. Do you understand that?
Yes, ma'am.
All right. Are there any special conditions to this probation? Have y'all negotiated any?
The state didn't have any real special conditions, obviously, other than follow the law.
Okay. All right, well, that is the sentence of the court. I need to ask if you have a weapons carry license. Do you have a license? Okay.
No.
All right, that's fine. And while you cannot have any firearms during the course of your probation, if you successfully complete all your probation, you'd be able to possess firearms again. All right, Mr. Farley, good luck to you. I know that you have a very successful business, and let's just make sure that that business is on the up and up and that you are following the law. All right, good luck to you. Thank you.
Thank you, Your Honor.
And is there somebody here from probation?
If you would wait, Ms. Jolly is on the way.
All right. Mr. Menadas, wait until the probation officer, Ms. Jolly, can meet with y'all and get all of that taken care of.
Yes, ma'am.
All right. Yeah, that'll be fine. And after you meet with her, then you are excused. Thank you. All right. Are there any other guilty pleas that are going to be tendered today? All right. So what I would like to do is, and we can just start up here with Mr. Mender, and I'd like the state to put on the record what the plea offer is. And I want everybody, all of the 4 defendants, and Mr. McMullen, we just heard from your attorney, and he believes he will be here by 11:30. He's apparently in Gwinnett County on some other case right now, and we'll have to just sort of wait until he gets here to handle yours. But this applies to you as well, for everybody. This is the final plea date. It's your first final plea before me. I know that y'all had a final plea before Judge Dempsey previously, but I gave you all the opportunity post the verdict in the case with some of the co-defendants to negotiate if you chose to, and have a final plea date, if you will. But this will be your last opportunity to enter a negotiated plea in this case, meaning you all in the state have agreed to a recommendation, and you can be assured that if I do not accept that recommendation, that you can withdraw your plea. Now, you can obviously at any point in time enter a non-negotiated guilty plea, And that would mean that you decide to plead guilty, and the state will make a recommendation as to sentence. Your attorneys will make a recommendation as to sentence, and it would be entirely up to the court to sentence. Could be above or below what any of the recommendations are, could be exactly what one of the recommendations is, but as long as it is within what is permitted by the statutes. And then, of course, you have the right and opportunity to proceed to trial on the case as well. Does everybody understand that?
Yes, Your Honor.
Okay. All right. So, Mr. Mender, you have this case pending, and you have another case pending as well. Is that right?
And Your Honor, so we were going to respectfully request to hold our announcement and to have an opportunity to approach the court at the bench whenever convenient before we move forward with the final.
All right. So I will come back to y'all. So, Mr. Garlington, and Mr. Mondelli and Mr. Abadi, can you put the offer on the record for Mr. Garlington?
Yes, Your Honor. Your Honor, on December 9th of 2024, the offer was relayed to counsel for Mr. Garlington as it relates to the possibility of tendering a guilty plea. The recommendation from the state was for the defendant to plead to count 1, conspiracy to commit RICO, count 49, which is the murder count, but it be reduced to the lesser included offense of voluntary manslaughter, and to plead to count 50, which is participation in criminal street gang activity, and then count 54, possession of a firearm during the commission of a felony, with a global sentence of 30 parolable time.
All right. And as a part of that plea offer, you all were going to null cross 40, 42, 43, and 51. Is that right?
That is correct, Judge.
All right. All right. And Mr. Mondelli, you discussed with your client the potential sentences that could be faced if he goes to trial and is convicted of all counts.
Yes, Judge, we've spoken extensively about potential risks of going to trial. I conveyed the offer to Mr. Garlington on December 10th, and we have had some discussions with Mr. Abadi since then. We are not in a position to accept the offer that's been placed on the record. We will be rejecting that offer. I will state that there are further discussions that are taking place. We understand the court's admonition, though, about any factors.
Yeah, and y'all can certainly present a joint recommendation. It's just not going to be negotiated per se at that point, in that you would have a right to withdraw the plea if the court didn't sentence in accord with that. But I mean, I will say, and this is certainly no guarantee, but I think across the however many years I've been on the bench now, I typically still, if there is a joint recommendation, certainly take that into account, and fairly often probably sentence in accord with that, but that is certainly not a guarantee. So, Mr. Abadi, would you be able to put on the record
And plus,
you understand that, Mr. Let me say another thing as well. I know that there was a not guilty or a not guilty verdict for most of the counts that faced the two defendants who proceeded all the way through to jury verdict. A trial for any of the four of you would be before a different jury. I would suspect that a lot of the evidence would be the same. The way it is presented might not be the same. I don't know, state's sort of story theory, if you will, might or might not be the same. And the ultimate outcome might or might not be the same. And I'll tell you, and I'm sure that all of your attorneys have told y'all, that acquittals with a jury are a rarity. So just keep that in mind. It does not mean that the same thing would happen to you. Y'all, we've got a different prosecutor at the table who I hope would stay through the trial of the case. And it just is probably going to look a lot different. There's also a different judge at the beginning. So just keep that in mind, but I understand that for now, y'all will be rejecting that offer. All right, so we've got Mr. Eppinger, and I know Mr. Eppinger still has a motion pending. I will tell, and Mr. Johnson, you should now have all of the transcripts from the main witnesses who testified around the 2 attempted murder counts at trial. And if we are not having a plea today, I'm obviously we're not going to have that hearing today, but I would be interested in going ahead and getting that scheduled. And I will say that I have heard the testimony as it was presented at the last trial, and I have seen the videos. I don't know what might be presented at the immunity motion, but I'm fairly certain that those 2 videos would be presented again, and I'm already familiar with that, as are y'all, having had it in discovery for a long time now. But we're going to go ahead with the final plea now. So even though that motion is still pending, any plea that you might be interested in tendering at some further point in the case, if you ever decide to do that, would be non-negotiated. Just
understood, Your Honor.
Mr. Eppinger, you understand that as well? Okay. All right. So, Mr. Body, can you put on the record what the offer tendered to Mr. Eppinger was, please?
Yes, Your Honor. The state's offer as it relates to Mr. Eppinger was a global sentence of life imprisonment as it relates to the armed robbery and everything else to run concurrent on this indictment. That sentence to run consecutive to the time he's currently serving in DOC custody, Your Honor.
All right.
Mr. Eppinger is facing a minimum of a life sentence and a maximum of 2 consecutive life sentences plus 145 years, Your Honor.
And I don't, this is just my quick count, but Mr. Eppinger is facing approximately 15 different felony charges on this indictment. Is that right?
That is correct, Your Honor.
All right. All right. And if he were to proceed to trial and be convicted of all counts, in addition to everything running consecutively so that it would be, I'm sorry, I think you said 2 life sentences plus 100 and how many?
165 years.
165 years. That time could also be run consecutively to the time that Mr. Eppinger is already serving on whatever he's convicted of already. So have you explained that, Mr. Johnson, to Mr. Eppinger?
Yes, Your Honor.
You understand that, Mr. Eppinger? Okay. All right. And was there something else you wanted to say?
No, I just based on the circumstances, I came to the podium.
Okay.
Announcement. But given the state's offer, Your Honor, at this time we would reject that offer based on our view and our view of the evidence in this particular case.
All right.
So yes, we would reject that matter and like to proceed to trial.
All right. And once I get through everybody, or maybe everybody we can get through right now, I'll talk about trial dates. And I'll talk with y'all first about in the immunity hearing date as well. All right. Thank you.
Your Honor, I believe that motion can be held as close to trial as possible.
Well, I mean, it could be, but I'm not interested in doing that. I'm interested in getting that taken care of as soon as possible.
Thank you, Your Honor.
All right. Not December, though. Not that soon. Okay. So have we covered everybody other than Mr. Mender at this point? Yes. All right, so let's talk about then the number of witnesses. I would think maybe about 4 or so for the immunity motion.
Statement of no witnesses.
None? Okay.
Your Honor, as far as witnesses in the case, I believe the only witness that may be necessary is the
You can pick it up. It's not.
is the complaining officer, Your Honor. That would probably be.
Okay, well, there are 2 officers who got shot.
Well, actually, there's only one who got shot. There's
Well, one who got shot at and one who got shot. You're right. I stand corrected on that.
So.
So your motion is just with regard to the one who got shot?
No, Your Honor.
I didn't think so.
No, it is related
Okay.
to both, but the other witness is not necessarily important for the
Okay.
motion.
All right, so that should be able to be taken care of in what, 4 hours at most?
I would imagine no more than an hour.
I mean, I think 2, but half a day at most, right?
I don't even think it'll take that long, Your Honor.
Okay, all right. So let's go ahead and get that scheduled then.
I guess I would have my inquiry with the court and counsel would be, it's the burden of the defendant to show that he's acting in self-defense. Typically, you don't call the complaining witness or the victim to establish your intent, how you're acting in self-defense.
I mean, if he wants, whomever he wants to call, he can call. And I get that, so do you think you'd be calling your client? Because it sounds like the state does not intend to call any witnesses.
Understood, Your Honor. It may be a situation where I may call my client.
Okay.
After discussion with him, and it may be a situation where we may the calling of the witnesses is just necessary for the introduction of the video, and we can make arguments based on that.
Okay. So let's look at sometime the week of January 13th.
Fine with the state. If it's just the video, the state would stipulate to the video coming in, Your Honor, making a.
Okay. All right. Did you, I don't know if you heard that, Mr. Johnson. If it's just the video, then the state would stipulate to it coming in. I think there were. All right, let's do 10 a.m. January 13th.
Your Honor, I did file a response.
Yes, I saw that. Thank you. I appreciate that. All right. And then with regard to the trial, we're at this point looking at potentially 4 defendants for this trial. Does the state have, I mean, the last time I asked, we still were facing 11 defendants. So do y'all have a revised estimate as to the time it would take to present the state's case?
I think it would be less than 90 days, but in an abundance of caution, instead of overpromising, I would say at the most 90 days.
All right. And when you say 90 days, you mean from the time we start presenting evidence till the time the state rests would be 3 months' time, not 90 days of trial time, right? Okay, just making sure. All right, and then obviously the defense would evaluate the state's case before determining whether they wish to present evidence. But any general idea what anybody thinks might get added on?
On behalf of Mr. Mender, if Mr. Mender was to go to trial, we would want 1 witness, and it would be who we would need a production.
Okay. Okay. Mr. Johnson, and I'm not holding you to it now, I'm just trying to get kind of an estimate.
Your Honor, based on our view of the evidence.
I need you to pick up that mic, I can't hear you.
Based on our view of the evidence, Your Honor, I do not believe that we'll have any witnesses for Mr. Eppinger.
Okay, and obviously that's assuming that it proceeds past the immunity motion. All right, and then I'll hear from Mr. Dark. But okay, so we're talking about probably still roughly 3 months. So 3 months is probably an overestimate on the state's case. Okay, so in terms of picking the jury, do y'all want to do jury questionnaires, or do you just want to have people in and do it all live?
There is a question as to how many jurors you call in.
So, I mean, if this were a typical case, I wouldn't call more than 72, but
My experience is that they are more comfortable being honest and letting their thoughts come out in the questionnaire.
in the questionnaire. Hey, excuse me. All right, so I know that at least as sort of a pilot project, Jury Services here in Fulton has some, I don't know, tablet type things that jurors can answer the questionnaire electronically, but I think they basically like come in, but just sit and answer the questionnaire, and then we have them back another day for follow-up. So we could do something like that if everybody's amenable to that. Okay, and have y'all thought at all, I guess did y'all already go through at least part of jury selection in this
We did.
prior iteration? Some of you did and some of you didn't, right? All right, so, I mean, I would need to know what type questions y'all want. So can y'all by, let's say, January 20th, have the potential questions that you all want asked?
And I think the previous questionnaire was sufficient, but it was redundant.
Well, we don't want redundancy. Not a fan. Well, redundancy every once in a while is a good idea, but I want to be efficient. Okay, so I'll pull and look at the last questionnaire, and if, y'all do the same, and if there are ones that you think we can strike, and any that you think we need to add, if y'all can just let me know that, and maybe we'll have, let's look and see what the 20th looks like. Maybe we can have, the 20th is the MLK holiday, so let's not do it that day. Let's do the 17th, which is the Friday before. Why don't we plan to just have like a status on, let's say 10 a.m. on the 17th of January? Where we can, so if y'all would submit whatever kind of additions, deletions you would like to the jury questionnaire by close of business on the 16th. We'll meet on the 17th for a status. And
The judge is that, everyone in this courtroom on 17.
everyone who is still wanting to proceed to trial at that point in time. And in addition, Mr. Dark. And then I know the state had proposed, did y'all say?
For indictment 22 SC 185532, indictment 23 SC 188183. My understanding in consultation with the state and your attorney is that we have a global resolution to all three cases. Is that correct?
That is correct, Your Honor.
All right, and you're going to be entering a plea of guilty to certain charges in these three indictments. So if you will you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? I need for you to tell me your name and spell it, please.
Shannon Jackson, SHANNON JACKSON.
Okay, put your hand down. Now, Mr. Jackson, the state has a series of questions to ask you. If you can, answer yes or no. If you need an explanation before giving an answer, let the court know and we will provide you with an explanation. If you need to speak to your attorney before giving an answer, let the court know and we will give you an opportunity to speak to your attorney. Do you understand?
Yes, ma'am.
All right, thank you. The state may proceed.
Thank you, Your Honor. Mr. Jackson, at this time, are you under the influence of any alcohol, drugs, or medicine that would negatively impact your ability to understand today's proceedings?
No, sir.
And how old are you?
32.
What's the farthest level of education that you've gone?
9.
Can you read, write, understand the English language?
Yes, sir.
And you're a little soft-spoken. Do you mind speaking up a little bit for Madam Court Reporter? All right. Now, do you understand that you were charged in case number 22 SC 181814 with possession of a Schedule 5 controlled substance, possession of a firearm during commission of a felony, possession of a firearm by a convicted felon?
Yes, sir.
You understand the maximum possible punishment on the possession of a Schedule 5 is up to 3 years in confinement.
Yes, sir.
You understand the maximum possible punishment on possession of a firearm during commission of a felony is up to 5 years, which would have to run consecutive.
Yes, sir.
You understand the maximum possible punishment on possession of a firearm by a convicted felon is up to 10 years in confinement.
Yes, sir.
Now, you're also charged in resolving today case number 22 SC 185532, in which you were charged in count 1 with serious injury by vehicle, count 2 entering auto with intent to commit a felony, count 3 theft by taking, count 4 failure to maintain insurance. Do you understand that as to count 1, the serious injury by vehicle, you could be sentenced up to 10 years in confinement?
Yes, sir.
Do you understand that for the entering auto, the maximum possible punishment for which you could be sentenced is up to 5 years in confinement?
Yes, sir.
And do you understand that for the theft by taking, based upon what the amount alleged in the indictment, that being greater than $5,000, less than $25,000, the maximum possible punishment for that offense could be up to 10 years in confinement?
Yes, sir.
And do you understand that count 4, the failure to maintain insurance, is a misdemeanor punishable by up to 12 months in confinement?
Yes, sir.
Now, as to case number 23 SC 188183, you were charged in counts 1 and 2 with participation in criminal street gang activity, count 3, possession of methamphetamine with intent to distribute, and counts 4 through 8 with possession of prohibited items by an inmate. Do you understand that for those counts 1 and 2, the gang activity, you could be sentenced up to 20 years in confinement?
Yes, sir.
Do you understand for the possession of methamphetamine with intent to distribute, you could be sentenced up to 30 years in confinement?
Yes, sir.
And do you understand the maximum possible punishment for each of those possession of prohibited items by an inmate is up to 5 years in confinement?
Yes, sir.
Now, do you understand that you have the right to plead either guilty or not guilty to any and all of these offenses? And if you pled not guilty, you would have the right to a jury trial in which the state would have to prove your guilt beyond a reasonable doubt.
Yes, sir.
Now, as your attorney, going over with you this form that I'm holding, the plea of guilty, acknowledgement, waiver of rights.
Yes, sir. I remember.
All right. And did you have an opportunity to review this form, go over this form in its entirety, and do you understand this form?
Yes, sir.
Now, Mr. Shard, are you waiving any potential defects in this indictment on behalf of your client as well as formal reading of the indictment?
So waived to both.
And Mr. Jackson, do you need any more time with Mr. Shard? Are you prepared to move forward at this time?
No, sir.
Now, in relation to this particular case, I believe you've been arrested on all of these offenses. Do you understand that if you enter this plea, that this also can be used in the future? It's what we call recidivist punishment, which means that if you got in trouble down the road, a court could look and see these convictions and therefore go ahead and sentence you to something greater than it normally would. Do you understand that?
Yes, sir.
You also understand there can be what we call collateral consequences to this plea. What I mean by that is that this can have a negative impact on, say, your ability to vote, your ability to have gainful employment, things of that nature.
Yes, sir.
Mr. Jackson, are you a United States citizen?
Yes, sir.
And do you understand this is a negotiated plea of guilty?
Yes,
Which means that your attorney and I and the state have come to a global resolution. We're going to go ahead and propose that to the court, and the court can choose to accept or reject that. However, if the court chooses to reject it, it could sentence you to something greater than what is negotiated. Do you understand that?
Yes, sir.
Now, do you also understand that if you were under probation or parole, that this can have a negative impact on your probation or parole status. And to be clear, this would not have a negative impact on the offense for which you just were sentenced, as all of these offenses occurred prior to entering this plea. Do you understand that?
Yes, sir.
Now, do you also understand that because this sentence will also include provisions of probation, that you will have to comply with all of those terms of probation, which also would include not possessing a firearm?
Yes, sir.
You also understand that possession of a firearm, aside from a probation violation, also would act as a new offense as you are convicted felon.
Yes, sir.
Now, do you also understand that there can be, let me get there. Do you understand that you're waiving any and all defenses, including any mental health defenses, by entering into this plea of guilty?
Yes, sir.
Now, do you understand? I'm going to read off a list of rights here. At the end, I'm going to ask if you understand you're waiving all of those rights, okay?
All right.
Do you understand that by entering this plea, you're waiving the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to assistance of counsel hired by you, or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
I understand.
Now, has anyone forced you, threatened you, or promised you anything to get you into entering into this guilty plea?
No, sir.
Now, your attorney has worked out certain cases in which, and certain counts in which you're entering a plea of no contest, as well as Alford v. North Carolina, okay?
Yes, sir.
So I'm going to go over each of these indictments specifically as to the counts. Do you understand Alford v. North Carolina is a situation in which you're not admitting that you are in fact guilty? However, you do recognize that it's possible a jury could convict you, and therefore you believe this is in your best interest to go ahead and enter into that plea. Do you understand that?
I understand.
All right, so we're going to begin with case number 23 SC 188183. You understand you entering a plea of no contest as to the participation in criminal street gang counts, which is 1 and 2.
Yes, sir.
You understand you'd also be entering a plea on Alford v. North Carolina in counts 3 through 8, which is the possession of methamphetamine with intent to distribute and the possession of prohibited items by.
Yes, sir.
Now, do you understand as to case number 22 SC 181814, your attorney has requested, and the state is not objecting, to an Alford plea as to the count 2, possession of a firearm during commission of a felony, and count 3, possession of a firearm by a convicted felon.
Yes, sir.
And then that your plea would be a plea of guilty as to counts 1, 2, 3, and 4 on the 22 SC 185532, that being serious injury by vehicle, entering auto with intent to commit theft. I apologize, you know me, I'm a lawyer. By taking failure to maintain insurance.
Yes, sir.
Now, Mr. Sharp, understanding that you negotiated these with other attorneys and sort of standing in place, could I fairly accurately summarize the counts for which are the no contest as well as the offer?
Yes, sir.
All right, understanding all of that, how do you wish to enter your plea?
Guilty.
All right, and could that be guilty as to on the 22 SC, the serious injury by vehicle, the entering auto with intent to commit felony, theft by taking and failure to maintain insurance, is that guilty?
Yes.
As to the 22 SC 181814, which is the possession of a controlled substance, the possession of a firearm during commission of a felony, and possession of a firearm by a convicted felon, as to counts 2 and 3. Is that under Alford v. North Carolina?
Yes.
And then count 1, the possession of a Schedule 5 controlled substance, is that guilty?
Yes.
And then as to 23 SC 188183, counts 1 and 2, the participation in criminal street gang, what is your verdict, or what is your plea?
No contest.
And the counts 3, possession of methamphetamine with intent to distribute, and then the counts 4 through 8, the possession of prohibited items by an inmate. What is your plea?
Guilty on the Alpha.
And is that plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand you would have only a limited right to appeal this guilty plea conviction?
Yes, sir.
And do you understand that for the felonies, you would have up to 4 years from today's date is to file what we call a habeas corpus, and that's if you wanted to challenge the constitutionality of this plea.
Yes, sir.
And do you understand that there is one misdemeanor on here, which is the failure to maintain insurance? Do you understand that you would have up to 12 months from today's date to also file that habeas?
Yes, sir.
Your Honor, I'm going to go ahead over what the factual basis is at this time for each plea, if it pleases the court. Judge, I will begin with the serious injury by vehicle case, which is the 22 SC 185532. Had this case proceeded to trial, the evidence would show that on June 7th of 2021, law enforcement responded to a motor vehicle accident on I-85 at Metropolitan Parkway, that location being inside of Fulton County. Judge, it was determined that this defendant was the at-fault driver in a motor vehicle collision that did result in the victim sustaining a fractured arm. Judge, there was a bystander that attempted to render assistance. Mr. Jackson then did leave from the scene in that bystander's vehicle without permission, that vehicle being greater than $5,000 but less than $20,000 in value. Judge, the defendant also did not have valid insurance at the time of the motor vehicle collision nor the departure from the scene. Judge, as to case number 22 SC 181814, had the case proceeded to trial, the state would show that on October 27th of 2020, law enforcement with Atlanta Police Department responded to an address on Judy Lane, which is located inside of Fulton County. They responded to that location because the defendant was parked inside of a driveway where he did not reside. Upon approach, law enforcement observed what appeared to be a prescription bottle. Judge, a canine came around and positively positively alerted as to contraband inside of the vehicle. The defendant was a convicted felon at the time. Law enforcement was able to locate a loaded firearm inside of that vehicle. Judge, in addition to locating promethazine, which was the Schedule 5 controlled substance. And Judge, finally, as to case number 23 SC 188183, while the defendant was at the Rice Street Jail located inside of Fulton County on March 29th of 2023, law enforcement conducted a search inside of his cell. Judge, that was a shared cell, and located inside of that cell included a cell phone, the pills that tested positive for methamphetamine. Judge, the quantity would be consistent with the intent to distribute, as well as a shank, which is often used in either self-defense or to be the initial aggressor or primary aggressor, depending upon what day it is at Rice Street. And Judge, possession of Apple AirPods and an iPhone as well. Judge, I'll begin with what the negotiated recommendation is on case number 22 SC 185532. That's the serious injury by vehicle. Judge, the state's recommendation on count 1 is 10 years to serve 3 years. However, that 3 years is commuted to time served. Count 2, the entering auto with intent to commit a felony, is 5 years probated to run consecutive to count 1. Count 3, theft by taking, is 5 years probation to run concurrent with count 1. And count 4, the failure to maintain insurance, is 12 months confinement commuted to time served. Judge, as to case 22 SC 181814, possession of a controlled substance, that judge recommendation is 3 years commuted to time served. As to count 2, that would have to run consecutive to count 3. So count 3 would be 10 years probation, and count 2 would be 5 years probation to run consecutive, for a total of 15 years probation.
I believe my understanding of the recommendation was that was going to be 10, the count 2 is going to be 10 to serve 3 commuted to time served, balance on probation,
Yes.
as opposed to 10 years probation.
I will defer to you as you were the one actively involved in negotiations on this one, Mr. Sharp.
Okay, so if you just go over those again for the record, for count, for 22 SC 181814. Count 1.
Is possession of controlled substance, that would be 3 years commuted to time served. Count 2 would be 10 to do 3 commuted to.
You can't do that if you're going to do count 3, because count 2, possession of a firearm during commission of a felony, is a mandatory consecutive. So you would have to have count 3, the possession of a firearm, at some period of time, so statute minimum of 1.
Okay.
So if we're going to do that, may I make
I don't have the indictment in front of me. I think what I meant to say is count 3. Count 3 would be 10 to do 3 commuted to time served, balance probated, and count 2 would be 5 years probation consecutive.
Correct.
The difference, Your Honor, is him essentially receiving a sentence of 12 years probation versus 15 years probation. The intent is It would be 12 years probation because he's already served those 3 years.
All right, so let's be clear. Count 3, 10 to serve 3, commuted to time served, balance on probation. Count 2, 5 years probation, consecutive to count 3.
Yes, Your Honor.
Yes, Your
And
Honor.
count 1, 3 years to serve, commuted to time served.
Correct, Your Honor.
Yes, Your Honor.
You may continue.
And as to case number 23 SC 188-183, as to counts 1 through 8, they all would be a concurrent 5 years to serve 2 years, the 2 years commuted upon time served. Judge, there are specific conditions that would go with these cases. Specifically, Judge, there was a negotiated from the trial division for a banishment from Metro Atlanta area as a condition of this sentence. He is to maintain gainful employment while on probation. There would be no contact or communication, either directly or indirectly, with any named co-defendant in the case number 22 SC 183572. There is to be no contact or communication directly or indirectly with any persons associated or affiliated with a criminal street gang. And there is to be no possession of a firearm on his person in any vehicle in which he occupies, nor any residence, quite frankly, just no possession of a firearm, given he would be a convicted felon. Judge, I also understand, and Mr. Sharp had approached me about concerns about being able to travel through the Atlanta airport. There would be no objection to an exception for the Atlanta airport. Judge, this is the only case that was assigned to my unit, and I believe it actually was initially with the high profile unit, was the gang case. And so, Judge, I do want to clarify for future cases why I am consenting to a no contest on counts 1 and 2, as it's not something I typically do, as this court's aware. Judge, the reasons for that is taking into account the working relationship I've had with Mr. Sharp over the years, who reached out to me along with Ms. Bumpus to try to resolve this case. Judge, understanding that there is multiple cases here, so I did not want to run into a situation where Mr. Jackson, who's had some incidents, unfortunately, at the jail, was remaining in jail while we litigated whether or not we were going to be dealing with a no contest on this case. And that is because also in this particular case, the typical negatives of a no contest plea for the prosecution are not present, specifically because he is already a C recidivist. This is irrelevant, frankly, whether or not we would be able to have three convictions in the future. Judge, understanding as well that the negotiated terms of the larger sentence include provisions of no criminal street gang activity, as well as the negotiation of banishment. Judge, I believe that that is a fair trade-off in taking into consideration the banishment provision. And Judge, from a factual basis as to this particular case, Judge, we are running into a situation, had this proceeded to trial, that this was in fact a shared cell. Judge, it's been in the past occasions where other individuals' contraband can in fact be found in other individual cells, or as well as the fact that there was a shared cell, so there's other individuals that would have had access. And Judge, in this particular case, I have not been made aware of any cellular dump in this particular case. Had a cellular dump been done in this case, and I've been provided with that, that would have demonstrated possession or control or intent over the narcotics or objects inside of that cell, we probably would be in a different situation. But I am not going to hold Mr. Jackson at Rice Street or ask him to be held at Rice Street while we did a cellular dump in order to ascertain that if we have a resolution that appears to be amicable to all parties. So just for future no contest cases, I wanted to be able to distinguish Mr. Jackson from other defendants that maybe argued were similarly situated.
All right, thank you. So will you go over the special conditions again so I can make sure I have them correct?
Yes, Your Honor. The special conditions would include banishment from the Metro Atlanta area with exceptions for the Atlanta airport. Judge, that would also include that he is to maintain gainful employment while on probation. There is to be no contact or communication directly or indirectly with any named co-defendant in the 22 SC 183572 indictment. There is to be no contact or communication, either directly or indirectly, with any persons associated with a criminal street gang, as well as a no possession of a firearm. I do understand it may take a little while for him to be able to sort out the interstate compact, Judge. So there's going to be a sort of a grace period, at least from the state, in relation to him being in Fulton County until he's able to go ahead and work that particulars out with probation for the interstate compact.
Because another jurisdiction has to accept him as a probationer,
That's
correct?
correct.
All right. Anything else?
Nothing from the state at this time, Your Honor.
All right, anything from defense?
Your Honor, I would just like you to know that Mr. Jackson is 32 years of age. His father is present here in court. His father works an honest job for an honest living. His wife is also present in court, supporting him. He has 4 children. And so a lot of these past acts involve selfishness, immaturity. And I believe that Mr. Jackson, throughout this whole legal process, has come to realize how valuable life is, and we only get one. And I think he wants to make everyone proud, all the supporters proud, and the people that have been here for him proud. So I know that he knows that he has people in his corner, and we're hoping, if Your Honor accepts this plea, we're hoping that this is something that we can all look back upon and say that this had a happy ending.
All right, so I have a couple of questions regarding the banishment. It's my understanding that he's from the metropolitan Atlanta area.
He is, Your Honor.
Okay.
He's lived here his entire life.
All right. So are there special circumstances under which he would be allowed to return during the period he's banished? Did the state negotiate?
Judge, again, that was a negotiated term outside of the one. I understand that there are going to be times in which this court would make exceptions, such as coming back for funerals or weddings. I understand this court traditionally does not do banishment outside of accepted negotiated terms. So to the extent this court is setting exceptions, I would defer to this court.
Your Honor, I anticipate that at some point in the future, there'll be a need to return back to Atlanta. I'm not trying to violate any agreements that I have with the state. The way I thought, quite honestly, the way I envisioned this happening was if there was a specific need, Mr. Jackson would reach out to me, and then I would reach out to Mr. Sperry. I know that creates more work for all of us, but I thought that that would probably be the best workaround at this time. And quite frankly, in the future, if things are going well on probation, then maybe we can revisit some of these conditions.
All right. Yes, but you have to tell us who you are for the record.
I'm Ms. Jones, Officer Jones with probation DCS. Due to the fact that where he's going, if they do not accept his case, we will have to come back in front of the judge to modify the sentence. I don't know that right now, and I won't know that until 7 days from today. I have spoken with my AC, so I am trying to get the situation expedited, but he won't go to probation until Thursday.
All right, thank you. So essentially what she's saying is until the state that you are moving to accepts your probation, you will be here in Atlanta, and everybody knows that, somewhere in the metropolitan Atlanta area. Okay. All right, as to indictment 23 SC 188183, indictment 22 SC 181814, indictment 22 SC 185532. The court is going to find that the defendant has entered a pleas that were willingly, knowingly, freely, and voluntarily given, and that there is a factual basis for each plea, be it no contest or an Alfred plea or just a regular guilty plea. All right, so we're going to start with '22 SC 185532. The negotiated and recommended sentence is on count 1, the defendant is to be sentenced to 10 years to serve 3 commuted to time served. Count 2, 5 years probated to serve consecutive to count 1. Count 3, 5 years probation to run concurrent to count 1. 12 months on count 4 commuted to time served. Count indictment 22 SC 181814. Count 3, 10 to serve 3 commuted to time served. Count 2, 5 years probation concurrent to count 3. Count 1, 3 years to serve commuted to time served. Indictment 23 SC 188183. On all 8 counts, 5 years to serve, 2 commuted to time served, balance on probation to run concurrent with 22 SC 185532, count 1. And also in 22 SC 181814, the sentences are to run concurrent to count 1 in 22 SC 185532. During the time of your probation, you are to maintain gainful employment. You are to have no contact with any co-defendant in 22 SC 183572. I don't want to assume, is he not related to any of those co-defendants?
Sure.
All right, okay. So the people who used to be your friends or the ones they say you used to be associated with, you can't have any contact with them. That means you don't respond to emails, texts, smoke signals, shout outs, Instagram, whatever. They're no longer people that you can have any contact with, because if you have contact with them, you run the risk of being violated on your probation and you end up in the Georgia prison system. And from my understanding, that's not the place you want to be. I understand that you were assaulted while you were at the Fulton County Jail. And unfortunately, that's no place anybody wants to be either. So the best lesson for everyone here is to stay out of the criminal justice system. At one point, when I was a judge on the Fulton County Juvenile Court bench, 88% of the people in the Georgia prison system did not have a high school diploma. So what that tells you is the best way to stay out of prison is to get a high school diploma. So you indicated you dropped out at 9th grade. You need to go back and get a GED so you can move forward in life. If someone wants to give you an opportunity, you can step up and take it, because you can check the box that I have a GED or a high school diploma. It is basically a weeding out process and basically indicates to an employer that you know how to show up and do assignments in a timely manner. That's all they're looking for. You will show up, do the assignment in a timely manner, and not cause any problems, because you've shown you can do that because you matriculated through high school. So they just want to know you're not going to be a problem and they don't have to worry about you. And more importantly, the court didn't want to have to look back and say, I just should have sent you to jail, as opposed to going along with this negotiated plea. You're getting a second opportunity. I suggest you take full advantage of it. You're 32 years old. I can say to you, based on what I've seen, the next time you get a felony conviction, you're going to be looking at a lot of years, and nobody's going to say yes to probation under any circumstances. So the banishment will be for 5 years because they didn't negotiate a term. So that's for 5 years, and you can come back for special occasions and the state and your attorney can work out what those occasions are. But you cannot come back unless you have been approved to do so and notice has been given to the state and they've signed off on it. You are not to have any firearm in your possession because you're a convicted felon. And you're not to engage in any street gang, criminal street gang activity. I assume that you know all of the co-defendants in 22 SC 183572. So you know the people that you're not to have any contact with. I always make this an issue with the state because I don't want to assume that the defendant knows these individuals.
He does not know all the individuals, but he knows who they are from going through the case.
So I would suggest that the state provides him a list of all the individuals, their known names and their street names, and any other AKAs they have out there. So there's no misunderstanding, okay? And your family members need to know that although you can have communication with them, they should not be carrying messages from any of these people that you're not to have any activity with. So, did I miss anything?
Your Honor, just one thing, if we could put on the sentencing sheet, that all these sentences are to run concurrent with the sentence that Mr. Jackson has from 22 SC 183572.
Any objection from the state?
No objection.
Okay, so all the sentences from 22 SC 181814, 22 SC 185532, 23 SC 188183 are to run concurrent with 22 SC 183572. At this time, does probation need to come on record and say anything? All right. She can't hear you.
I'm sorry. Unless you want me to tell you, well, the court, or I'm going to tell Mr. Jackson, I can talk to him.
Yes, just put it all on the record about reporting.
Okay, so he will report on December 19th to 276 Memorial Drive, Atlanta, Georgia, 30303 at 8 a.m.
So don't be late. Don't miss that appointment because they will come back to court and ask me to issue a warrant for you failing to appear. Do you understand?
Yes, ma'am.
All right. So at this time, is there anything else from either party?
Judge, just Mr. Chardon recommended. I have no intention of leaving my office anytime soon, at least voluntarily. So Mr. Chardon and I have built up a point of trust and communication over the years. I have no problem with Mr. Chardon reaching out to me if there's any exceptions that are necessary.
And also for the record, I will waive fines and fees for these 3 cases since he's already on probation in another case.
Thank you, Your Honor.
All right. If there's nothing further, then all parties are excused.
Thank you, Your Honor.
Your Honor, that concludes the business after probation is done.
Yes.
See you tomorrow.
All right.
Position 7 on the final plea calendar.
Hold on.
Excuse me, position 1 on the final plea calendar.
All right. Position number 1, indictment 23 SC 186907. Marquisha Knox.
Sorry, Judge, Ms. Knox needed to feed the meter, the parking meter, when you first called the calendar.
All right, Mr. Marquez, is this your case?
It is.
What's up, guys? Thanks for tuning in. Hey. Just getting going here this morning in LA. They're going to be back. I think there's somebody else going to take a plea. I didn't catch who it was, but we had Miles Farley, the Make America Slime Again creator. Gosh, I can't believe he didn't have any criminal history. Now he's on 5 years probation for that stupid RICO charge. He did an Alfred plea. And yeah, and then so they're on a break, and I'm not sure what time they're coming back. But I heard the Judge Whittaker say that it sounds like somebody else might be taking a plea. So we'll watch that. Let's see if we can go back to what she was saying here.
Can we have a deadline for a discovery Dropbox link?
I would sincerely hope that all the discovery has been shared by now.
I know they're working on consolidating some of the new stuff that came out as it relates to during the trial.
Okay.
But that shouldn't take very long. I know Mr. Dark has received the majority of, it's just taken a minute, over 8 terabytes file for Mr. Dark. So that's been the focus. But I will make sure.
Yeah, so if you, the state, could put together your narrowed, cold, focused discovery.
Yes.
Can you get that? When do you think you could get that to all the defendants? Because even if they have everything, they'd probably rather have the smaller universe of things.
The first week of January, is that appropriate?
Yeah, that works. All right, so that would be, find my calendar again. January 3rd. By close of business, January 3rd. All right, anything else we need to think about right now? All right, everybody else, I'm going to go ahead and release Mr. Abadi. Obviously, you'll need to stick around, and we had an anticipated 11:30 arrival time for Mr. Dark, so we'll hold on to Mr. McMullen as well, and then once we have Mr. Dark, we'll reconvene for his final plea and to discuss with him the deadlines we've set. Was there something else, Ms. Fagan? Oh, sure, yes, I'm sorry, you did mention that.
Okay, so it's Nard who's going to take the plea. And she said 8:30, at 11:30. So here any minute now, they should be back. Reconvene. We'll go live here. Just cooking up some eggs. I'll be back on in a minute.
possession of a firearm from March 17th. So the jury found guilt on that one count. He was sentenced to 10 years to serve 3, commuted to the time he served. So he had 7 years of probation going into today already. The sentence is 15 to serve 3, commuted to time served, balance probated concurrent with that. So essentially, today he's gone from 7 years of probation to 12 years of probation.
So given all the cases, basically, it's 12 years of probation
Yes.
that he's now dealing with.
Correct.
No, it's concurrent. Concurrent. 12 total.
On the other plea they took with Judge Whitaker.
He has 7 years probation, and now this is 12 years, but it's running concurrent. Yeah.
I know there's attorney-client privilege, but in general, are you able to just share? You're pretty reflective in there, talking about how he's grown up, he's learned a lot, he has 4 kids. Either one of you can talk about just kind of what his mindset is as post this chapter.
The thing about Shannon that I love about Shannon is he cares deeply about people, and I think that this whole process, and probably certainly at the age he is now, where he's more reflective, he's realized how much certain people mean to him in his life, and it's just a matter of we talk often, and I'm not going to share too much, but we talk about life, and I think he realizes he's beginning to realize what's really important in life, and I've encouraged all those people also to make sure they continue to be there for him, and he just sometimes I think we get so used to trying to survive on our own, and we forget that there's people there to support us, and sometimes we need to lean on those people, and that's what I'm hoping he will do, because I know there are many good people that are going to be there for him.
When do you expect him to obviously touch the grass?
So we've already been in contact with the sheriff department. The paperwork needs to go to the clerk of court. Then the clerk of court needs to fax it to 901 Rice Street, and they need to look it over. But I'm anticipating he would be released later on today. And if he's not, then when I wake up tomorrow, that's going to be first on my agenda, is to figure out what's going on.
Is anyone from his family wanting to talk or share their thoughts on his release now?
I don't think so. I think everyone's just appreciative, and but I don't think anyone wants to go public to make any statements at this time.
Mr. Kokomo, how are you folks today? Oh, very good.
No, I just hope that we can keep fighting and pressing for Mr. Kendrick so we can get him out sooner than later.
And Ms. Pompous, are you also one of Mr. Jackson's attorneys?
I'm a halfway co-counsel.
She is.
Okay.
She's
I
being
just
modest.
wanted to make sure I wasn't, yeah.
She is co-counsel. Yes.
Does
Good.
he prefer, haven't been covering the whole thing. Does he prefer Mr. Jackson or Mr. Stillwell, or what should we?
So he prefers Jackson.
Okay.
He was listed as Stillwell in the indictment.
Right.
For the trial, and I just got so used to referring to him as Mr. Stillwell because I just thought it would be easier for the jurors to keep track of one name, but he does prefer Mr. Jackson.
Is it, because I guess we've referred to him as Mr. Stillwell in the other case.
Right.
Would we say Mr. Jackson, also known as Mr.
Yeah, that would be fun.
I like Jackson too. So did he tell you when the first meal was when you'd like his first meal to be? I heard rumors many floating around. Do you want to know what his first meal is going to be?
I told him I got I got him at Five Guys.
Oh,
I'm simple, man. So,
Nah, budget, bro. Come on, get that stuff.
nah, he'll be all right.
for Mr. McMullen, and I went ahead when I was addressing the rest of the remaining defendants and let Mr. McMullen is the last opportunity.
Yeah, I'm sorry, he was trying to say something.
Yeah,
but I'm
no, go ahead. Go ahead.
Yeah, we're good.
Okay, this will be the final opportunity today to enter a negotiated guilty plea. And that would be a plea that both sides have agreed to a recommendation. And if the court accepts the plea that sentences to something outside of that recommendation, Mr. McMullen would have a right to withdraw his guilty plea. After today, any plea that is tendered would be non-negotiated, meaning that if he decided to enter a guilty plea, any sentence that was statutorily authorized would be a possible sentence, and there wouldn't be any right to withdraw the plea simply because of dissatisfaction with the sentence. I just wanted to make sure, and I know Mr. Dark, you've told that to Mr. McMullen already, but wanted to make sure that's on the record. All right, and I'll ask Mr. Abadi to please let me know what the state's offer was.
Yes, Your Honor. On the 8th of December this year, the state sent an email to counsel for the defendant where the state agreed, or the state's offer was the defendant plea to count 1, conspiracy to commit RICO, and then count 2, but the lesser included offense of murder, voluntary manslaughter, with a sentence of 20 years to serve, all of that time being parolable or parole eligible. It's my understanding that at this time, the defendant is not accepting that plea offer. So he'd be facing a mandatory minimum if convicted after trial of life and a maximum of life without the possibility of parole plus 20 years, Your Honor.
All right, and do you understand that, Mr. McMullen? All right, and as I mentioned before, the fact that there was an acquittal of certain of your co-defendants does not mean that there would be an acquittal in a trial before a different jury with, different prosecutors, different defendants, different defense attorneys. So it's a chance that you are taking, and you obviously have the right to proceed to trial. You also have the right to enter a non-negotiated guilty plea, although you could only enter a non-negotiated guilty plea to the charges that are in the indictment. I, as the judge, don't have any authority to reduce charges. So what I mean by that is, unless the state agreed to permit you to plead to voluntary manslaughter instead of murder, the only pleas I could accept would be to the murder and the conspiracy to violate RICO. So it's the prosecution's sort of venue, if you will, ability, and only theirs to lessen the charges. Okay, you understand that also? All right. Okay, Mr. Dark, is there anything you want to put on the record right now?
No, Your Honor.
Okay, and we discussed some timing already in your absence when I had the rest of the attorneys here. And what we all have settled on is the state gave an expected duration of trial of about 3 months. They think that's probably on the outside, but that's what we will anticipate at this point. We are going to have a status conference in this case on January 17th at 10 a.m. And we're going to discuss jury questionnaires and the voir dire process and things like that. And can you let me know, Mr. Dark, I know that some of you started the trial that already occurred, started voir dire, and some of you didn't, and I don't know what Mr. McMullen did. Was he a part of the past trial when it started?
Your Honor, Mr. McMullen told me that he's in custody for the past 2 years with no counsel, so I don't believe that he would participate.
Okay, all right. And when did you become involved in the case, Mr. Dark?
I just was appointed, I cannot remember right offhand, but I know it was in the last 60 days, I think, Your Honor, 60 days or more.
Your entry was August.
August, yeah.
And that's a lot more than 60 days. That's more like 5 months.
August in the other case, and then in this case, it was in July 19th. I think it was.
Yeah, 'cause he
5
has
months.
some other case or something. But Your Honor, as I was saying at the last court appearance, I just got the discovery on this case on, I think, the 11th. And then I don't know whether these other matters.
And as I said to you at the last conference, you should have been able to get all of the discovery from you said there was no prior attorney? Okay, well, it was your responsibility when you were appointed to the case in July to reach out to the state and say, hi, I'm in the case now, I need the discovery. So I'm not going to delay the case past the trial that we're going to have of all of the remaining co-defendants. So you're just going to have to spend your holidays getting up to speed.
To be clear, I'm not asking for a delay. I'm just putting on the record the conditions under which I'm working, and I want to be effective for my client. I don't think that he should just be forced into trial just because, for whatever reason, an attorney was finally found for him after 2 years. Okay, well, there was no trial for him within the last 2 years. If you were appointed in July, you've already had 5 months, and you'll have at least 2 more months to get ready. 7 months to get ready for a 2-count case is plenty of time. So use your time wisely. Mr. Abadi, did you already provide Mr. Dark with the discovery? I know we discussed that on December 3rd.
Yes, Your Honor. I believe it's everything, but I want to make sure I'm 100%.
Okay.
Yes.
All right. So the other dates. Lost my place now. Lost my place. Okay. So we are planning to at least start from the jury questionnaires that were used in this prior version of this trial, which should be filed, and any additions or deletions that you would like have to the court and opposing counsel by close of business on January 16th. And any and all motions in limine are due by close of business on January 15th. The state is going to take a critical look at the discovery and potentially narrow what is going to be used at the trial. So you should have everything now, but everything may become a smaller subset of what you have now. And so they will get that to all of the defense attorneys by February 3rd so that you know what you don't have to worry about in terms of discovery. And we are looking at February 24th to begin the trial. And sometime between January 17th and February 24th, we may, before that date, get the jurors into, we're envisioning them coming in to answer the jury questionnaires on tablets. And so that we've got an electronic version of their answers, and they're here. I mean, they may be here, they may be up in jury in the, I don't know if they'll be in the courtroom or not, but somewhere in the courthouse to answer the questionnaires, then get those to everybody and then have them back to do actual jury questioning and jury selection. So we'll talk about the ins and outs of all of that on our January 17th conference. All right. So do you have any questions for me, either of y'all, with regard to how the case is going to progress? All right. Okay. Then how about you, Mr. McMullen, do you have any questions for the court? All right. Are you going to want a few minutes to talk with your client after this, or did you have enough time beforehand?
I wanted to follow up because he had a question when we started.
All right. Okay. All right. We're gonna go ahead and finish this, and then I'll give y'all some time to talk in the back. I want to talk with you before you go back there, though, Mr. Dark, about the appropriate way to handle attorney conflicts. All right. So this hearing is out of close. Thank you.